Okay, we're going to get it started here today. Good morning, everybody. Happy Tuesday. Welcome back to another session here. And today we're going to talk about the buyer agency contract. This is important in regards to the NAR settlement. Like we discussed previously, and if you watched Hank Lerner's message from last week, our buyer agency contract for Pennsylvania and PAR is very extensive, and it's been protecting us since the 90s. There's a lot of good information in here in explanation to your client. But with that being the case, Kong's going to take us down through it and give us a rundown of what's in it and why it's important.
Thanks, Brooks. So the buyer agency contract is so important, more so now than ever, because it's the buyer agent's livelihood. It's how you get paid, right? It outlines in detail how you get paid, what the buyer can expect when they enter a property, start looking at a property, all the way to purchasing the property. Okay. I know a lot of times buyer agents write on the contract, and I always have to laugh on the last page. Property is being sold as is, or the list agent demands that it's being sold as is. But if you read this contract, this buyer agency contract, it already tells the buyer that the property is being sold as is. All real estate is being sold as is. So the first part of this contract is the top portion, talks about the broker, agent, licensee, your contact information, license numbers, and then it also has the buyer's information. I know a lot of times I see these buyer agent contracts and all you have on there is the buyer's name. It would help if you have it filled out completely with the address, phone number, and email as well. Okay. Just so that when you turn in the deal to Seth, he has all that info and he can keep a record of it for you. Okay. Buyer understands that this buyer agency contract is between broker and buyer. Okay. So it's between the broker and buyer, not buyer agent and buyer. So it's with Remax First Advantage and the buyer. Does buyer have a buyer agency contract with another broker? So see, this contract, even if you go through it and sit down with a client, it even asks that question for you. So if they answer no, then it's no. If they answer yes, then you have to go into a little more detail and find out, well, who do you have a buyer agency with and where are we sitting here? Okay. Section number 1 is the starting and end dates of buyer agency contract. It's also called the term. Okay. There is no set recommended term for this contract. That's part A. Part B talks about the start date and end date of this contract. This contract applies to any property that buyer chooses to purchase during the term of this contract. Any property, okay? Could be a for sale by owner. It could be another listing by another co-broke, another agency. Or it could be technically even if they buy something from their own family member, right? It says any property buyer chooses to purchase during the term of this contract. Buyer will enter a buyer agency contract with another broker licensee that begins before the ending date of this contract. So the starting date, this contract starts when signed by buyer and broker unless otherwise stated here. So you don't need a date there if you're going to start immediately after this buyer signs this contract. But if you're going to post date or predate it, that's where you enter this start date. Okay. The end date, the contract ends right before midnight on the end date. Okay.
Kong, if you don't mind, I just want to mention 2 things. If you look at line number 17, remember how we talked about how our association has done a great job with protecting us for years in comparisons to the other states in the United States, only 18 of it were doing right. But look at number 17, no association of realtors has set or recommended any term for this contract. And then as you get into part number 2, line 27 says the same thing with regards to commissions. So the media who is portraying this as commissions weren't negotiable, everybody was charging 6%. It says right in our agreements on line 17 and line 27 that no association of realtors has set or recommended any broker's fees.
You're right.
So I just think it's important for everybody to understand who's panicking that we have been doing it correctly all along.
And then also, Tim, lines 18 through 19, even though broker's fee or portion of it may be paid by seller or listing broker, broker will continue to represent the interest of the buyer.
Correct.
Okay, so it's always been in our contract. It's just now we have to really explain it because the media has
Sensationalized
sensationalized
situation that maybe wasn't relevant to our area.
Exactly. So part 2 talks about the broker fee. No association of realtors has set or recommended broker's fee. So it's in there 2 times in half a page. Okay. Broker and buyer have negotiated the fee broker will receive for exercising professional knowledge and skills in locating and assisting buyer in the acquisition of real property, which is available and suitable for buyer. Part B, broker's fee paid by buyer to broker is as follows. Okay. In a purchase transaction, 1A, with a seller represented by a real estate broker, the fee is blank percentage of the purchase price or a flat fee. That's where you enter your flat fee number. Whichever is greater, and $ blank, which is your broker fee that you wish to charge. Okay. 1B talks about with a seller who is not represented by a real estate broker, the fee is a percentage of the purchase price or a flat fee, whichever is greater, and your broker fee. We have seen so many times agents come to us and ask us to help them enforce a buyer agency contract, and that's blank. Okay, can't enforce 0%. Number 2, broker's fee in event of a lease transaction is blank. Okay. So again, you can put in there if there is a client that's looking to potentially lease as well. You know, they're coming to the area, they're not sure they want to buy or lease. That's one way to get paid as well. 3, it is broker's policy to accept compensation offered by the listing broker. So 3 times now it's in here. If the amount received from the listing broker is less than the amount in paragraphs 2B1 in a purchase transaction or 2B2 in a lease transaction, buyer will pay broker the difference unless seller agrees to pay the difference as a term in the agreement of sale. So right there, if we start seeing 0% or whatever, a number that's less than what you were expecting from your buyer when you had them enter into this contract, that right there, that line is telling the buyer that they have to cover the difference.
Does anybody have any questions on that? Or does anybody want Kong to go over that section one more time? Because this is the most important section, really, of this call.
Yeah.
Don't be shy to speak up.
2B3 is probably a line you should highlight and go over with your buyer even more so, more than ever before. Okay, number 3.
Tim, this is Sherry. I have a question.
Yeah.
So it says, unless it is specified as a term in the agreement of sale. So are you gonna give us ideas of how to put that in there? Would it have to be closing cost help, seller assist? Is that the only way to do it, or what else would be options?
Right now, it's business as usual. You know, this closing cost help part of it is only going to be possible if that's the way they redesign the forms in July. But Kong, can you explain that one more time about how this thing works with regards to the fee and if it's not being offered or the
Sure.
amount's not offered correctly?
Sure. I'll just read it over again real quick. It is broker's policy to accept compensation offered by the listing broker. If the amount received from the listing broker is less than the amount in paragraphs 2B1 in a purchase transaction or 2B2 in a lease transaction, buyer will pay broker the difference unless seller agrees to pay the difference as a term in the agreement of sale. So commissions has always been, you should really negotiate before you even show the property or write an offer on the property, right?
But I think to answer part of Sherry's question for now, if you were to, before, we had clients that weren't willing to show a property maybe that was listed at 1% and that they wanted, let's just say 2.5%. They didn't have to write that in. They just needed to notify the other agent to see whether or not the seller would agreeable to pay that, and then use the compensation form that would be signed to do that. I don't know, Kong, what your opinion is as far as writing it into the contract, but if the other agent is agreeing to that compensation, it would be their responsibility as the listing agent to either take it out of their commission or renegotiate the listing commission with the seller. Or do you think, as Sherry's saying, it should be put into the agreement of sale?
Well, in this case, it says buyer will pay broker the difference unless seller agrees to pay the difference as a term in the agreement of sale. So it has to be as a term in the agreement of sale.
Okay,
And
then
that's
the
my
compensation.
question. Yeah, the
Yes.
term, would that just be seller help, or are we allowed, when we get to this point, probably the forms will be changed, but let's say they start doing 0% now, could a term on the agreement of sale be writing for seller to pay so much buyer commission? I don't want to start writing language. I don't know. It's just weird. It says, because our cooperating broker is between brokers, not buyer and seller, but then the agreement is between buyer and seller. So I'll just listen to what you guys have to say.
Yeah. I think Sherry's right. And what you're saying, Kong, as a term in the agreement of sale, it should probably, in order for this agreement to be enforced, it would probably be needed to be written, instead of writing language, ask for the closing cost help, as Sherry said. That way, the buyer then has the money to satisfy this agreement that they've signed between the buyer's agent and the buyer. Do you agree with that, Sherry?
Yeah, I that's the easiest and simplest.
Yeah.
Because then we're not really writing language, we're just adding a percentage to the agreement of sale that has the closing cost help for the buyer, which gives the buyer the money to satisfy the difference.
And assign co-broke, reflecting that difference.
Right. Well, the co-broke form would be irrelevant at this point because the money's coming to the buyer as closing cost help. And then on the buyer's side of the settlement sheet, we'd be enforcing the difference in the buyer agent agreement.
True.
You know what I mean?
Yeah.
In that way, we're not rewriting language on this thing. So
Yeah.
let's just say, for instance, using a hypothetical number of the 3%, that we had, an agent had 3% listed in this agreement, and the listing agent was only offering 2% co-broke commission. What we would then do would be put 1% in closing cost help for the buyer And then on the buyer side of the settlement sheet, we would be charging them 1% to even out this agreement, and then be collecting 2% from the listing agency and the seller on the settlement sheet. And that would enforce this buyer agency agreement. Does that make sense? Or do you think that's wrong?
No, that's the way to do it.
Yeah,
I just
that's
think
what
by the time this is coming around, is it June or July?
July.
Okay, I'm sure PAR will have a new form for us.
But that's probably based on all the seminars that I've listened to and webinars, the way it's going to be. It's going to be in the form of closing cost help or seller concession. And then even lenders are publishing right now that they are allowing that to be on the buyer side of the sheet to enforce the buyer agency agreement.
Tim?
Yep.
Wouldn't, wouldn't that additional 1% be covered in the cost estimate that you figure out for the buyer?
It depends, and that's a good question. Because if that's the way you're planning on fulfilling the contract, it would be in there. One of the things that we just learned in Gary Muccio's class was every time there's a change to a contract during negotiations, we should, as agents, be filling out revised buyer cost sheets and revised seller cost sheets every time we have a change in terms agreement that involves monies to be paid. So the answer to your question, Bob, is yes, it should be done up front so that the buyer knows exactly what their responsibility to bring to the table is. And number two, I'm just adding to it, that it should be done during any change in terms agreement. So if, for instance, the buyer does a home inspection and they don't like what's in the agreement and they negotiate, $2,000 worth of seller concessions, then the seller's closing cost sheet should be revised by the listing agent, and the buyer's closing cost sheet should be revised by the buyer's agent. And I assure you, 90% of the people are not doing that. And that's something we got to make sure we do. 10% probably does do it, but 90% probably does not do it. Seth, is that an accurate statement or not?
I don't think Seth's on here. I think he has continuing ed this morning.
Okay, all right. Go ahead, Con.
Number 4 talks about upfront money. Blank dollars of broker's fee is earned and due, non-refundable at signing of this buyer agency contract. Okay. By the way, if the buyer prepays for something, who do they make the check out to?
The broker.
100% of the time.
Yep.
Not
And
agent.
there are agencies, even locally, that are charging that fee to a buyer right up front. We're not advising you either way. That's totally up to you how you run your business. But that line has been in that form since it was created.
Right. It's also on the listing contract as well. No,
I
Sherry?
have another quick question, sorry. So this might be something that we're gonna try to have buyers pay something up front. Because what if a buyer's like, okay, I know I have to pay the difference, and now it's a week before closing, and the buyer's like, oh, I don't have that extra 3,500, sorry, deal goes south. Let's get something upfront that's non-refundable. And it's going to be difficult for buyers to agree. What if they back out because of inspections? Would that be one reason that it would be refundable? Or I guess we just keep it until our buyer agency term expires. I'm hoping they get a house within a year if our term is a year. But, I'm thinking, oh my gosh, it's a week before closing and they're not getting seller help, but they need
Right.
that extra money. It's like, oh, sorry, I spent it. I went on a vacation last month. I don't have it now. I can't close. Well, all of us who have worked so hard for 6 weeks to get to closing, a lot of agents will probably say, oh gosh, you know what? I don't want to go through this again. Instead of my 5 grand, okay, can you just give me 1 grand?
I don't know, because what if somebody turns over a large sum of money and we never find them a house, or we can't negotiate a deal that's acceptable to a seller for them? I think what companies previously were using that line for is maybe a smaller fee to cover their gas expense and their time expense, that they're not out running around for nothing. But I don't know that a large expense will be acceptable to a buyer, because in the market that we're in right now, there's in the market they're in right now, they might be one of 20 offers, and let's say they don't get a house during your term, then what happens? I mean, because the money's non-refundable. You know, one of our agents just sent me a text message and said there was an agent from a local real estate company that was charging, a flat fee of X. Okay. But there was also, like I said, there was a company that was doing that locally too, and it was a small fee, but I'm just not sure that there would be a lot of buyers that would be agreeable to pay it. For instance, what if they don't get a house? What happens then? Are we going to return it, or are we keeping it as non-refundable?
And I think, wouldn't we just be adding it onto the buyer's cost sheet, and the lender would verify that they have all the money? So just like them going to closing now, I mean, they can't decide that they don't have that extra money. So it is on there. And
Yeah, but Aaron, as Sherry said, they might have it on there now, but what happens if they go on a
Yeah,
Cancun vacation and spend it,
it's happened. We've had a client buy a wedding ring
Sure.
before.
Yeah,
DTI was shot
yeah, the loan was denied because their monthly expenses were incurred that, what was it, Kong, a week or two before settlement?
Yeah.
They went out and bought a wedding ring.
Oh, man. So, but to answer Sherry's question, if you're going to do something like that, that probably would go on line number 5 as other, because line 4 is it specifically says non-refundable. So part C, I mean, we're already 26 minutes into this as professional realtors on a buyer agency, yet there are agents out there that just slips this document and never explain it, right? It's crazy. The balance of broker's fee is earned if buyer enters into an agreement of sale during the term of this contract, whether brought about by broker, broker's licensee, or by any other person, including buyer. If buyer defaults on the terms of an agreement of sale, broker's fee will be paid by buyer to broker at that time. Buyer is advised that contacting a listing broker or seller directly may compromise broker's ability to earn compensation from a listing broker and could result in buyer's obligation to pay a fee to broker. So this is actually a very important paragraph now, especially with what's upcoming here. This is stating that you're going to get paid if the buyer defaults on the property. If they get cold feet and walk away from the property, you're still entitled to your fee that you set forth in this buyer agency, right? It also states that with this upcoming change, that if buyer consults with the listing broker directly, they're compromising your position, right? I mean, they're not going to just go around you and buy a house without you getting paid. Okay. That's why it's so important. It's bolded too. You just have to sit down with your buyer and go over that and play out these scenarios. Okay. Any questions on that paragraph, Jim?
So just as an example, if they were to to back out for legitimate reason, of course, the inspection goes bad or they can't come to terms and they get the deposit back. We're not talking about that here. This is like somebody gets cold feet or they back out for a reason that's really not an option under the contract, correct?
Says if buyer defaults,
Defaults.
Right. But that's what we mean by default, correct?
right,
Okay.
yep,
Oh, if a buyer defaults, but the seller was paying the commissions through seller help, then is the only way to acquire money is to file a judgment against them? I mean, how would you really have them pay you at some point?
well, okay, I think what you were saying, Sherry, is if in the contract, the buyer or the seller agreed to pay the commission, right? And then the
Correct,
buyer
but-
defaulted, how do you collect from them? It still goes back to B1.
Yeah, if the buyer's agent, or if the buyers have signed an agreement that says you're gonna get X amount of dollars, although the listing agent is offering a commission that's acceptable to you, and the buyer backs out of the deal, our recourse at that point would be to take this agreement of sale to the district justice and file a claim as long as it's under $12,000. And that has been done many times by companies, including our own company, where we've gone to enforce a buyer broker agreement. Sometimes you win, sometimes you lose, and you could have a rock solid case. And I've seen a district justice offer the buyer's agent $1,000 instead of the whole commission that was agreed upon. So even when you think you're 100% right, the district justice makes up their own decision.
Did that answer your question, Sherry?
Yes, uh-huh.
Okay, good. Part D, if buyer enters into an agreement of sale for a property after the end date of this contract, buyer will pay broker's fee if the agreement of sale is a result of broker's actions during the terms of this contract. So they sold the house with you, right? Or the property was seen during the term of this contract. And buyer, this is important here, part 2 and 3 are together, okay? They coincide. 1 and 2 is an or, either or, okay? So the property was seen during the term of this contract and buyer is not under another buyer agency with another agent. Okay, so they saw the house with you, your buyer agency expired. The next day they find another agent, they go back to that same house, make an offer, get it accepted and settle. That's what that's talking about. Then you're not entitled because they have a buyer agency with somebody else now. Okay. Any questions on that section? Okay. Part 3, dual agency. Buyer agrees that broker and buyer's licensee stated above may also represent the seller of the property buyer might buy. A broker is a dual agent when a broker represents both buyer and seller in the same transaction. A licensee is a dual agent when a licensee represents buyer and a seller in the same transaction. All a broker's licensees are also dual agents unless there are separate designated agents for a buyer and a seller. If the same licensee is designated for buyer and a seller, the licensee is a dual agent. Buyer understands that broker is a dual agent when buyer is viewing properties listed by broker. So this is covering you in dual agency. It's the disclosure within the buyer agency.
So Kong, I have a question that I'm going to bring up to Jim Goldsmith on this Get the Facts meeting on Thursday. I've watched a lot of videos here lately, and I don't know what the actual answer is, to be quite honest. So let's say that a buyer goes directly to the listing agent now, but the listing agent isn't willing to be a dual agent, and the buyer is unrepresented. Are we allowed to prepare an agreement for a buyer who's unrepresented?
Yes. I think that's in the consumer notice.
Because it's just something I'm not 100% sure of.
Yeah.
We've done it in the past, but whether or not it's legal or not, I don't know. Because in other states right now, people are saying that if the buyer is unrepresented, it's their obligation to have someone like an attorney prepare an agreement of sale and present it to us because we represent the seller. We shouldn't be preparing agreements for a unrepresented buyer. So if we can find that in a consumer notice, that would be great. Otherwise, it's a question I'm going to ask Jim Goldsmith on Thursday.
Yeah.
Brooks, do you know anything on that?
Well, I'm just sitting here thinking about this and just throwing this out there. It would be more like, in a different market, we used to do reverse offers,
Right.
an offer from the seller to the buyer. In that instance, you're preparing the document for the seller's signing off on it first, and then it's simply emailed to the unrepresented or delivered to the unrepresented buyer, and what they choose to do with it is on them. But you didn't prepare the documents for them. You simply prepared those on behalf of the seller.
Which you would most likely want to get the seller to sign first.
Yeah, that's what I was saying. Have them
That
sign
would be
off
the
first.
seller's offer to the buyer.
Yeah.
Tim.
Yeah.
Consumer notice. Regardless of the business relationship selected, all licensees owe customers the duty to provide assistance with document preparation and advise the consumer regarding compliance with laws pertaining to real estate transactions.
Okay. Well, then that answers it for Pennsylvania.
What a great state we live in.
Yeah. What a country.
Designated agency. Designated agency is applicable unless checked below. Broker designates the licensee stated above to exclusively represent the interest of buyer. If licensee is also the seller's agent, then licensee is a dual agent. Okay. Number 5, brokers' services to others. Broker may not take action that is inconsistent with buyer's interests. However, broker may provide services to a seller for which broker may accept a fee. Such services may include, but are not limited to, listing property for sale, representing the seller as a seller agent, deed doc prep, ordering certifications required for closing, financial services, title transfer and prep services, ordering insurance, construction, repair, or inspection services. Providing such services is not in itself a breach of broker's fiduciary duty to buyer. Okay. Part B, broker licensee may show the same properties to other buyers and may represent those buyers in attempts to purchase the same property that buyer wishes to purchase. See, that's in here already too. With the limited amount of inventory right now and the number of buyers, I've had buyer agents write 2 to 3 offers on the same property for different buyers. And it's right here. It's allowing you to. Broker does not breach a duty to buyer by showing a property buyer is interested in to other prospective buyers.
Now, I'm the first one to admit I never knew that line was in there.
Yeah.
Or if I read it, I forgot it. Is there anybody on this call that knew that that line was in that agreement? Speak up now or forever hold your peace.
Shelley.
Okay, good. Because you're absolutely right, Kong. This has happened a lot over the last several years with competing offers where an agent would call me also and say, what should I do?
Mm-hmm.
Yeah.
Now, part C, though, it is a conflict of interest when broker or licensee has a financial or personal interest in the property and or cannot put buyer's interest before any other. If broker or any of broker's licensees has a conflict of interest, broker will notify buyer in a timely manner. For example, if I want the same property my buyer does. Okay.
Yep.
Part 6, this contract, the entire contract. This contract is the entire agreement between broker and buyer. Any verbal or written agreements that were made before are not a part of this contract. All changes to this contract must be in writing and signed by broker and buyer. So it's stating that this is the contract between you and your buyer. Anything else that was said beforehand, it's irrelevant unless it's in writing now at the time of this signing, okay, or after.
Phone question.
Hey, Bob.
Back up to the section where you could represent 2 or 3 buyers on the same property.
Mm-hmm.
Your fiduciary responsibility is to the buyer, is my understanding. So at that point, do you have a responsibility to tell each of the buyers that you're working with another buyer for the same property and advise them in a similar manner?
You already did disclose it by when they signed this document.
You lost me.
You already told them that there's a potential for you to represent another buyer of the same property when that buyer signs this document. You don't have to repeat yourself again. They already know that potentially you could by signing this agreement, this buyer agency. They are already acknowledging that, yes, there is a potential for Bob to show this house to another buyer. Brooks, you have a comment on that?
I understand what you're saying, but that's
Yeah.
really fuzzy.
The only thing I would add is, so long as they definitely read it, understand it, and or you explained it to them. Simply just sending it out via DocuSign, if that was to go to mediation or court or something like that, you have an obligation to explain what's inside of this contract. So you gotta tell them about that potential, and that's defined in this section or paragraph 5 of this agreement.
Right. Yep. That kind of answer your question, Bob?
Yeah, it does. What the one question I would have if I was a buyer though is, well, if that's the case and you're representing another buyer, what did they offer?
I think we have a confidentiality
Yeah.
requirement to all parties to
Right.
keep everything confidential.
Yep. Number 7 talks about the transfer of this contract. If the brokerage ever changed names or partnered with another company and changed its name, then they're agreeing from the start that they're agreeing to the transfer. Okay. Number 8 talks about confidentiality. Unless permitted by buyer or required by law, broker will not knowingly reveal or use any confidential information of buyer. Buyer understands that sellers or sellers reps, okay, the seller or the listing agent, might not treat the existence, terms, or conditions of any offer as confidential unless there is a confidentiality agreement between buyer and seller. This paragraph will survive the termination or expiration of this contract.
So Kung, could you elaborate on that for everybody so that they understand what that means? It's not necessarily, there's some listing agents that'll say, okay, send me your highest and best. And there's other listing agents that might say to the next buyer's agent, hey, I got 400, for this right now. If your buyer wants it, they're going to have to do better than 400. So what that's saying is the listing agent can shop the offer. And that the buyer with this particular agent understands that that even though their agent is held to confidentiality, let's say if they're representing another buyer, the
Yeah.
listing agent is not held to confidentiality with regards to the terms that were offered, correct?
Right, that's exactly what that's saying, Tim. The buyer agent has a confidentiality agreement with the buyer for this contract. But once that offer is out of the buyer agent's hand and into the list agent's hand, then the list agent doesn't have that same obligation to this buyer. He or she can shop this offer and say, hey, yeah, I have a 400K offer. Can you do better? Okay. I think a lot of times agents don't do that. Listing agents don't do that because one, they don't know that that's allowed. And two, they don't want to lose that deal in hand if it ever got back, right? So, yep. So that's in there, okay? 9, expertise of real estate agents. PA real estate agents are required to be licensed by the Commonwealth of PA and are obligated to disclose adverse effects about a property that are reasonably apparent to someone with expertise in the marketing of real property. A, if buyer wants information regarding specific conditions or components of a property which are outside of brokers or licensees' area of expertise, buyer is encouraged to seek the advice of an appropriate professional. For example, the septic system, okay? If buyer wants financial, legal, or any other advice, buyer is encouraged to seek services of an accountant, lawyer, or other appropriate profession. 10,
Now, Kong, before you go to the next one, Sherry, are you still on the call?
Yes, I'm here.
Okay. If there's anybody that's had more instances of septic issues than Sherry, I'd be surprised. Because she has run across, I'd say in the last 5 years, a lot of septic issues. Is that not correct?
Not that I want to have them, but yeah, I've
No,
dealt
I
with them.
know. But like, for instance, I got a text message from one of our agents this morning that says, that they offered 475 on a 495 house and didn't get it because they had a septic inspection. And I said to the other agent that lost it, our agent, it's very risky to sell a house without a septic inspection. And all I was saying is, I know you've been through a lot of them. You probably don't like to sell houses either, I would imagine, Sherry, without septic inspections, knowing how many inspections you've gone through where you've had to negotiate out repairs and or new systems. Is that right?
Yeah, so one of my most recent listings about a month ago, there were 3 offers. So one was no inspections, but the price was 35,000 less. And then the other 2 were kind of neck and neck. They both had home inspections, but one also had a septic inspection. So she's like, for $2,500 less, I'll pick the one that's not having a septic, just because it's been there since the 70s. Never had problems, has it pumped every 3 years, but she's like, I don't want to go with the unknown. So it's up to the seller what their risk level is, I guess.
Yeah, it's just very scary, because I know somebody right now who, 2 weeks ago their septic was working and now it's not working. And they're probably going to have to put in a new septic system. And it's just, when you hear of a house that was built in the 70s and they got the existing septic, for me, even if I lost the property, I'd still want to have an inspection. But I can understand the seller not taking that. Hopefully that there doesn't become an issue right after settlement. But
I mean, in one other example, I had a listing, 6 months ago in Grantville. And it had holding tanks. I mean, they were put in 20 years ago, 3 like 1,500 gallon holding tanks, because 20 years ago they couldn't get a perk and probe to work. So when I listed it now, of course, we disclosed, they've had holding tanks. They've been pumped every 3 months and what the cost was. So the buyer said, well, I want to have a perk and probe just to see if now the soil might work. We did do that. It failed, and the sewage enforcement officer said the only option would be to bring topsoil in, let it sit for 4 years. And then after 4 years of it sitting, then we can put a specialized septic system in there. I don't know if it was an EcoFlow or peat tank system, whatever type of system. So in this case, the seller was like, I'm not dealing with escrowing all this money, doing all this stuff. He literally sold the house instead of 240. He sold it for 150 as is, move on. So every seller has their motivation levels, and you just have to give the seller all the options and timing and money up front. And in that case, he's like, I just want to get rid of it. So now it's on the buyer.
Yep, yep. Well, that'll give them the money to pay every 3 months to get it pumped until the 4 years goes by. That's for sure.
Part 10 talks about the deposit money, and it coincides with the agreement of sale as well. Broker will keep or will give to listing broker, who will keep all deposit monies that broker licensee receives in an escrow account as required by the real estate licensing laws and regulations until the sale is completed or an agreement of sale is terminated, or the terms of a prior written agreement between the buyer and seller have been met. Buyer and seller may name a non-licensee as the escrow holder, title company, in which case the escrow holder will be bound by the terms of the escrow agreement, not by the Real Estate Licensing and Regulation Act. Buyer agrees that the person keeping the deposit monies may wait to deposit any uncashed check that is provided as deposit money until seller has accepted an offer. Regardless of the parent. Sorry, Sam.
Excuse me, if you can scroll back down.
Yeah.
Let's look at that again. All right. We know what, if we hold the escrow or the listing agent holds the escrow, we know what the terms of that agreement are as far as the release goes. That we have to have a mutually agreed upon signature by all parties before we're allowed to release it, or after that number of days in the contract, then it can be released within 30 days if no legal actions have been stated. But what is bound by the terms of the escrow agreement? So let's say it's being held by First Advantage Settlement Services and not RE/MAX First Advantage. What are the terms of the escrow agreement? Are they the same terms that are in the contract, or are there some other terms? Because I know I've had deals where, just to make it simple, I've had them go right straight to First Advantage Settlements. Do you know what the terms of this escrow agreement are?
I'm just reading over it again.
No, I know. Take your time. And is there a difference between the escrow agreement and the Real Estate Licensing and Registration Act?
We'll have to look that up.
Yeah, but it's something we might want to put, Brooks, in our comments to Jim Goldsmith when we get to get the facts straight.
Yeah.
Just a quick question. Why would it be simpler to go to the title company as opposed to RE/MAX First Advantage?
In some of my larger transactions that I've had that were really fast settlements, I had the money sent directly to the title company versus the real estate company, just so that we wouldn't have to be waiting for a wire to come in, or back in the other old days, it was waiting for a check, and then the check to clear, and then them write a check to the, escrow company or the title company. I just did it that way several times.
Or if, remember,
Because
this contract is-
you're allowed in the agreement of sale to write who you want to hold the money.
or if there's a dual agency or dual brokerage situation between the same company that doesn't have an escrow account.
So we might want to get educated on that one a little bit.
B, regardless of the apparent entitlement to deposit monies, Pennsylvania law does not allow a broker holding deposit monies to determine who is entitled to the deposit monies when settlement does not occur. Broker can only release the deposit monies, one, If an agreement of sale is terminated prior to settlement and there is no dispute over entitlement with a written agreement. So that's your release portion, okay, a signed release by both parties. 2, if after broker has received deposit monies, broker receives a written agreement that is signed by buyer and seller, directing broker how to distribute some or all of the deposit monies. Okay. 3, according to the terms of a final court order. Or 4, according to the terms of a prior written agreement between buyer and seller that directs the broker how to distribute the deposit monies if there is a dispute between the parties that is not resolved. I think possibly,
Like
you
when
write in
we
there-
have a non-refundable that's
Yeah.
held and not held by the seller, and it's held directly by the escrow account, but it's listed as non-refundable.
Part C, buyer agrees that if buyer names broker or broker's licensees in litigation regarding deposit monies, the attorney fees and cost of the broker and licensee will be paid by buyer. Okay.
Yep.
11, Civil Rights Act. Federal and state law makes it illegal for a seller, broker, or anyone to use race, color, religion, or religious creed, sex, disability, physical or mental, familial status, children under 18 years of age 40 or older, national origin, use or handling, training of support or guide animals, or the fact of relationship or association to an individual known to have a disability as reasons for refusing to sell, show, or rent properties, loan money, or set deposit amounts, or as reasons for any decisions relating to the sale or rental of property. Notice regarding convicted sex offenders, Megan's Law. The PA General Assembly has passed legislation, often referred to as Megan's Law, providing for community notification of certain convicted sex offenders. Buyers are encouraged to contact the police department, or the PA State Police for information relating to the presence of sex offenders near a particular property, or to check the information on the PA State Police website. Okay, so that's kind of, it's putting the research onto the buyer's hand.
Right. Now,
If it's a major concern for them, okay?
that's been a concern of a lot of buyers in the past. Tracy Weigel, are you on the call? Tracy on? No. I know Tracy's experienced that, and she points that out to every buyer to check that. The difficult thing about that law is if anybody gets on that website, you would be shocked, absolutely shocked at how many sex offenders live in your own area. I mean, unfortunately, they're everywhere.
Yep.
Today.
13 is buyer's inspections. Unless buyer and seller agrees otherwise, real estate is sold in its present condition. There it is, as is. It is buyer's responsibility to determine whether the condition of the property is satisfactory. Buyer is advised to carry out an inspection at buyer's expense by qualified professionals to determine the condition of the structure or its components. Areas of concern may include, but are not limited to, electrical, plumbing, heating, ventilation, and air conditioning, appliances and fixtures, water infiltration, basement, roof, property boundaries, asbestos, mold, and indoor air quality, carbon monoxide, radon, and environmental hazards or substances, wood destroying and insect infestation, on-site water service and or sewage system, property insurance, deeds, restrictions, and zoning, and lead-based paint. Buyer should discuss inspections and any special needs with licensee. B, buyer is advised that information regarding properties considered for purchase by buyer has been provided by a seller or a seller's broker. Such information may include, but is not limited to, the information on the seller's property disclosure statement, including environmental conditions, MLS info, including information regarding restrictions, tax assessments, association fees, zoning restrictions, dimensions, boundaries, if identified, and marketing information. Unless otherwise noted, broker has no verified, unless otherwise noted, broker has not verified the accuracy of this information and buyer is advised to investigate its accuracy.
Brooks, is there anything you want to bring up on this one?
Yeah, I mean, everything's deemed accurate, but not guaranteed.
Yeah. I mean, we just had a situation recently, and it becomes very complex with this whole thing, to be quite honest. You know, a buyer comes in, they buy a property, waive all inspections. The seller represents the condition of a swimming pool. After the walkthrough, it's noted that there are problems with the swimming pool, that the seller represented that there were no problems with the swimming pool, even though there weren't inspections. So, you know, this has not only happened in this particular case, it's happened to us one time with a pipe breaking where the property is not in the same condition that it was represented and the buyer walked away from the deal. And then there's a fight over the deposit because they waived all their inspections. But again, it all falls back to when I've been on some of these continuing ed calls, the Association of Realtors is saying that the majority of deposit disputes are a result of the seller's property disclosure. So if the property disclosure is marked as unknown, it's one thing, but if it's marked as no, and then you find out that there is a problem prior to settlement, it literally gives the buyer the opportunity to walk away from a deal. So just wanted to bring that up.
Thank you. Number 14 is becoming a lot more popular because of the Ring doorbells and such. Recordings on the property. A, any person who intentionally intercepts oral communications by electronic or other means without the consent of all parties is guilty of a felony under PA law. Buyers should not make recordings on the property that capture the oral statements of other persons without having the full consent of all persons who are parties to the communication. Buyer should be aware that a seller's property may contain smart home technologies or devices which may record or allow for remote monitoring of the seller's property, including broadcasting or recording video and audio. Buyer should be aware that any discussions, including discussions of negotiation strategies held on the property, may not be confidential. Okay. It's pretty self-explanatory there. C, buyer hereby releases all brokers, their licensees, employees, and any officer or partner of any one of them and any person, firm, or corporation who may be liable through them from any claims, lawsuits, and actions which may arise from any audio or video recordings occurring in or around any property considered for purchase by buyer. 15 talks about the recovery fund, which the consumer notice also goes over. Pennsylvania has a real estate recovery fund to repay any person who has received a final court ruling, civil judgment, against a Pennsylvania real estate licensee because of fraud, misrepresentation, or deceit in a real estate transaction. The fund repays persons who have not been able to collect the judgment after trying all lawful ways to do so. For a complete detail about the fund, call that 717 number. Special clauses. The following are part of this buyer agency contract if checked. A single agency addendum. And then part B is any additional terms. Now, these bold statements down here are kind of CYA clauses here. Buyer has read and received the consumer notice as adopted by the State Real Estate Commission. So they signed and acknowledged that they signed the real estate consumer notice. Buyer has read the entire contract before signing, so they've read this contract. If buyer is obtaining mortgage financing, buyer shall promptly deliver to broker a copy of all loan estimate and closing disclosure upon receipt. Buyer gives permission for broker to send information about this transaction to buyer's fax numbers and or email addresses listed. Okay. That's another reason to have the email address for the buyer listed, because it's giving you the right to email that address. Right? Return of this contract and any addenda and amendments, including return by electronic transmission, DocuSign, bearing the signatures of all parties, constitute acceptance by the parties. Okay. So this is covering you for electronic signatures as well. This contract may be executed in one or more counterparts, each of which shall be deemed to be an original, and which counterparts together shall constitute one and the same agreement of the parties. So let's say you have one party, let's say in a divorce situation, you have the wife sign one, and then the husband signs the exact same one, but their signatures are not on the same document, but it's for the same property, everything's the same in it. It's just two documents. It still constitutes as one. That's what it's saying. Okay. Then finally, lastly, a notice before signing. If buyer has legal questions, buyer is advised to consult a PA real estate attorney. And buyer signs, and then it is accepted by or on behalf of the broker by licensee or broker. There you
So
go.
Kong, there's one thing I'd like to say about the execution of these agreements. This is very important. I brought up to you a little earlier that I was in a district justice hearing where, even though we thought we had a rock solid case, the district justice only awarded our agent $1,000. Okay. Well, there was a little bit more to the story. Turns out the buyer was a police officer in the same district as the district justice, number one. And number two, the buyer, who was the police officer, said, I never signed that agreement. My wife signed it with DocuSign. So the agent was sending out the DocuSigns and the wife signed it. You know, there's been multiple cases I've had them myself where they have one email address. Don't, just when you think you're not going to have a problem is when a problem arises. So my thoughts are, when you're meeting with a buyer, get these things signed when you're first meeting with them and you're having your little mini session with the buyer. Get them signed then, get them to sign it with ink and not DocuSign these agreements when you're writing a contract, because it's important. If you do have a problem, or if you want to enforce this agreement, which is what this call was about today on how to enforce it, make sure you spend the time at your initial meeting getting them to sign the consumer notice and getting them to sign a buyer agency agreement for a particular period of time and whatever commission you're willing to work for, and make sure you explain this to them. It just took us an hour and 7 minutes to go over this agreement. Now, we went over it very slow, but I'm sure you could probably at least spend 45 minutes going over this agreement with your buyers. It might take you an hour. But again, the reason for this call was, with the way things are going to happen in the future here, it's important for you and us as agents and brokerages to understand this agreement, this buyer representation agreement, and it's important for us to understand or let the buyers understand what the consequences are, meaning if we decide to enforce it. So meet with them in person, get this stuff signed, stop docu-signing this agreement of sale or this buyer representation agreement and the consumer notice. I'm encouraging you that if you want to enforce it when a problem arises, make sure you do it. Another agent, myself, talked last week during coaching about a lot of times on listing agreements and stuff, I would always, when we would get to the commission, let's just say whatever the number is, I would circle it. Whatever we were paying out, I would circle it. That way, if there ever came up a question of, you never explained it to me, I could pull the agreement up, show it to them and say, look, I circled it. You know, we went over this. So as agents, we need to be really careful with our paperwork right now, especially in the society that we're in and what's going to happen here in the future. Again, not to repeat myself, but if you want to know how to enforce it, meet with them and go over. Kong, you did a great job presenting this. Brooks, thank you, both of you, for your knowledge. Does anybody have any questions they'd like to go over?
I'd like to make a comment. All of these mastermind meetings are good, but this is one of the best ones that I've ever had.
Thank you, Bob.
Thanks, Bob.
Anybody else have a question about the agreement? If not, if you want to watch it again, Brooks will be editing it and then sending it out to everybody. Dad, is there any final comments you'd like to say to the group? If Brooks, can you unmute Poppy?
I can only ask him to unmute. Hang on one second.
Poppy, can you unmute yourself? There you go.
Yeah, do you hear me now?
Yep, we can hear you now.
Okay, it was a great meeting. I'm glad you brought up the circle part of when you're going over the contract. Look, the beginning of every deal is everything. If you have it down pat in the beginning and you have gone over this contract with your people, you're going to have less problems. The problems begin with, is like you say, you send it out, DocuSign it, nobody reads it, everybody signs it, and then the crap hits the fan. We need to engage and get on this ahead of time. I would like to suggest, and maybe the other people on the group might do this too, that we let's bring these problems up in the beginning of the mastermind meeting, so that we're always searching for content. And I would say that we can, if we have our people addressing this stuff in the beginning and telling us about problems, we can always come up with a great subject. Okay?
Thank you, Dad.
Yep.
Brooks, any final remarks?
Just want to reiterate, from Hank Lerner's video last week, our documents are already giving us a jump start on this NAR settlement. We are very well protected with them. All that content in there protects us if the seller isn't offering a commission. But I don't want people dwelling and speculating on what ifs and, outlier scenarios that might exist. As Kevin Sears from NAR said last week in his video, look, with this settlement, buyer agency compensation is still going to be allowed, lawful, and permitted. However, it's just not going to be permitted within the MLS. And he's confident that NAR's members will, figure out a means of distribution of that information. So when you're having conversations with your sellers, explain the commission model and why it makes sense to offer that type of commission model, because it's the most inclusive of all buyer segments out there, and it was designed for stimulating competition and ultimately getting them the highest price. So have those conversations with your clients. If you haven't read through these agreements in their entirety, whether it's the buyer agency agreement or the listing agent agreement, make sure you get to know that thing like the back of your hand and thoroughly explain these documents to your folks.